Good morning. I like that. Good morning.
Good morning.
Yeah, I like that even better. We are so proud to have all of you come out on a Saturday morning, bright and early, and you all look quite alert. So we're very glad to see that. I'd first like to make some acknowledgments of our visitors. So if you are a first-time visitor, would you please stand so that we can recognize you? All visitors, please stand. Yeah. Thank you very much. We also have a distinguished guest with us as well. We have Mayor Ed Elliott, and he'll be speaking to us at the end of the program. But we will get to the heart of the program and the reason that most of you have come, because we have an outstanding program today. One of the things that is a hallmark of the League of Women Voters is our programming. And we have topics that, number one, you as the members said, this is what I want to know about. And so today, we're going to be looking at the judicial branch, or the Kansas Judiciary. And we'll be talking about selection, retention, and issues that are facing our courts today. You know, when our founding fathers put together the Constitution, they had vision and they had the wisdom to create a government that is lasting and that has been able to be flexible enough to withstand the test of time. And so it is because it is the government of the people, by the people, and for the people that all of us are such advocates for our democracy. And so one of the things that I will tell you a little story, very brief, about how this program came about. And it has something to do with the two doctors, Dr. Janice McMillan and Dr. Dolores Furtado. Actually, I worked with Dr. McMillan. And I had asked her about the program. The first program that my co-vice president and I were looking at was about the Kansas Judiciary. And I called to ask for resources. And then about the next day, I called and asked them if they would head the government committee called JOCO in the Know. And Janice said, well, we're kind of looking at the Kansas Judiciary, something about it as well. What we do know is that the judges have a very tight schedule. Therefore, I don't know if an evening program will really work for their schedule. And I said, why don't we combine it? And so this is the first time that we've had JOCO in the Know as well as a general meeting, and we're very excited about it. Now, I've done some internet trolling about the persons who are on the panel. I've checked them out, let me tell you, but they're all extremely distinguished. But Janice McMillan knows them very thoroughly and knows them personally. So I'm going to have her come up and introduce our panel, and they will take their seats here. Dr. McMillan.
Thank you, Ann, and I have to say I was not one of the trolls. But I'm so glad to see so many of our members, and there are a lot of guests here this morning, and I think that's just terrific. Many of you remember this from your high school civics class probably, but the court functions at three different levels: the Supreme Court, the Court of Appeals, and the district court level, of which there are 31 in the state of Kansas. Today's speakers represent each of those three court levels. Justice Dan Biles is a member of the Kansas Supreme Court, and he very enthusiastically agreed to participate in the program. Prior to being nominated to serving on the Supreme Court in 2009, he practiced law for 24 years here in Overland Park. In reviewing his biographical sketch on the court's website, I learned that Justice Biles and I have something in common. We both grew up in the same hometown, but I was there a few years before Justice Biles, and neither of us chose to stay there. The Court of Appeals is represented by Judge Karen Arnold-Burger. Prior to her appointment to the Appeals Court in 2011, she served as the municipal judge for the city of Overland Park. Judge Arnold-Burger and I both served on the 10th Judicial District Nominating Commission, and during that time we had the opportunity to consider Judge Kelly Ryan for admission to the district court here and forward his name to the governor. And that brings me to telling you a little bit more about Judge Ryan. He is a member of the 10th Judicial District Court, and which is here in Johnson County. He was appointed to the court in 2008. Prior to that, he had a private law practice and worked in various Kansas counties as a prosecutor, a county attorney, a district attorney, and a municipal court judge. So he has seen a lot of issues related to the courts. Paul Davis zoomed in on the interstate just now. Paul will serve as the moderator this morning. A practicing attorney and a former state legislator and a candidate for governor in 2014. I think Paul is well known to all of us for his commitment to good government. And so I will turn it over to Paul and the panel. You all have cards on your seats, and so if you have questions, we will pick up those cards after all of the presentations, and we will ask the members of the panel to answer some of those questions for us. So sit back and enjoy and learn.
Well, good morning. It's a delight to be here. I don't know whether I'm happy or not to see judges this morning because I may or may not have broken a few traffic laws on my way here.
It's all right, you'll win on appeal.
Sort of wishing that Judge Arnold-Burger was maybe still the municipal court judge in Overland Park. But it is a delight to be here, and it's good to see a very nice crowd because what we're talking about this morning is something that's very important and certainly something that is going to be on the forefront of a lot of Kansans' minds and should be as we are moving towards a November election that really is like no other in terms of discussion about the role of judicial selection and retention and the kind of judiciary that we want to have here in Kansas. I am acquainted with all of these three people, and I can tell you that we could not have better panelists to represent the judiciary this morning. In Janice's introduction, you got a little bit of a flavor for their backgrounds and the breadth and depth of experience that they bring to the judiciary. And I think you're going to have a treat this morning to hear from each of them and hear their perspective and probably learn a few things about what exactly our different courts do and the role that they play in our judicial system and that they play in our democracy. So keep those questions in your mind as they are filtering through as you hear the comments from the judges and justice. And you'll have an opportunity to ask those questions. What we're going to do to begin with here is to allow each of the panelists to make a few comments about what they do and the role that their court has, and perhaps give us a little bit of a perspective and a look into what a judge does, whether it's on the district court level, Court of Appeals, or at the Supreme Court. So I'm going to begin at the top, because if I didn't, I might be breaching protocol and get in trouble if this went up on appeal. But I'm going to ask Justice Biles to begin, and yes, ma'am, you've got.
I'm sorry, could we ask the panelists to stand when they talk?
I think we probably could. And there is a podium if you want to use that, whatever you are most comfortable with. I know that there's folks in the back probably can't see us very well because we're not on an elevated stage. So if panelists could stand up, it's kind of nice to be able to tell a judge that you need to stand up every once in a while because that's usually what they're telling me. But Justice Biles, I will turn it over to you.
Well, one of the things the Kansas Supreme Court does is have responsibility for the license.
I see. Okay.
One of the things we do is we have responsibility for the licensing of lawyers. And so there is a process by which we look at mistakes made by lawyers. One of the mistakes that was made just now was that we met, and we decided we would start with the district court. So that's strike one. So we're going to start with the district court, and basically the idea is to kind of take you through the progression that a case might take. So we'll start with the local level first, and then we'll go to the Court of Appeals, and then we'll go up to the Supreme Court. That's what we're doing.
Throughout my years practicing law, I've never been able to read the mind of a judge. Clearly, that hasn't changed.
I can read Justice Biles' mind because I worked with him for about 20 years as he was my senior partner. And he's on the Supreme Court, and he always tells us what to do. Thank you all very much for having us today. It's wonderful to be here. I want to tell you all, this group as a whole is very supportive, has been in the past, has a great history of supporting the 10th Judicial District. I'm not used to people telling me to speak up. Both the 10th Judicial District as well as all the issues related to our court system, which also includes, I can't get by without saying this, and especially since Mayor Commissioner is also here. We'll talk about courthouse tax coming up as well. But I am a district court judge, Division 17 in Olathe. This is the 10th Judicial District, the entire county. There are counties out in western Kansas that a district makes up 6 counties to make up a district. And they may have fewer judges or more counties, but it's all supposed to be based on, in relationship to the number of cases, the number of people, and the business of the courts. There are 31 judicial districts in the state of Kansas. Of those 31, and we'll talk about this more because we wanted to also get into this process, we're talking about retention, selection, merit selection, all of those issues, that across the board, each district in the state determines how they choose their judges. And there are, of those 31, 14 of those judicial districts have elections, partisan elections, to choose their judges. 17 districts, including Johnson County, or the 10th Judicial District, are by merit selection. We'll talk about that here in just a bit. In Johnson County, we have 23 judges. There are some judicial districts that have 1 district court judge. That is because of the fact that we have approximately 580,000 people in our county, and we have one of the busiest, if not the busiest, court in the state, by sheer volume, if by nothing else. Of those 23 judges, and we'll talk about this in the breakdown of the court system, 19 of those are district court judges, and 4 are called magistrate judges. The difference there is magistrate judges have a limited jurisdiction. Without getting into all of those issues, if you're familiar with this, you may have appeared in front of a district magistrate judge. They handle smaller value cases, literally what are called limited actions. They have some more limited jurisdiction from what a district court judge would hear. Of those judges that are magistrates, there are 2 types in the state of Kansas. There are magistrate judges who are not lawyers. That's not well known necessarily outside. We know that all the time. They're euphemistically called law-trained judges, which are lawyers who are magistrate judges. All district court judges are attorneys, or licensed attorneys, to become a district court judge. So that you also understand, a good example was talking about the case that was just ruled on yesterday. There's a federal court system, which is wholly apart from what we're talking about here. We're talking about the state court system. And part of the state court system is also the municipal courts. The shining example of Overland Park Municipal Court for many years was Judge Arnold-Burger, who was the chief judge. For how many years were you there? 20. She started when she was 4. But the municipal courts, that may be, unfortunately, as Paul mentioned before, that may be where he would be appearing for a traffic ticket or any other smaller violations that have jurisdiction within the cities. There's 23 different jurisdictions, cities, municipalities with municipal courts in Johnson County. Go all the way from Overland Park, the largest city, all the way down to Spring Hill, Edgerton. I was a prosecutor and a judge, different times, in Edgerton. We didn't do all of those, no. Edgerton, we only had court twice a month, whereas Judge Arnold-Burger was having 2 dockets in the morning, 2 dockets in the afternoon. It was a full-time position. So, municipal courts is where a lot of you might have, if it's a neighbor problem, a barking dog, code violations. Not that any of you would have that, I'm not saying that. But the district court level is what we're going to talk about as we progress up and then into the appellate courts. And don't let it fool you that whatever we do, we know that it's worse than being on videotape. Everything we do is reviewed by them. They review and tell us whether we did it right or not. They can explain that. In Johnson County, we have the benefit, by having these 23 judges, that we can specialize, and we have to. All of the things that come before a district court include the large breadth of family law cases, divorces, child custody, child support, paternity or parentage cases. That takes up 5 of our judges in Johnson County. 5 judges to hear all of those cases, and that's all they hear. Now, in these other counties and other districts throughout the state, by volume, judges have to be kind of jack of all trades, and they may have a morning docket with criminal cases, and then go hear their divorce cases, and then come and hear the contract or the medical malpractice case in the afternoon. They cover the whole gambit. And we don't do that because, and family court's a good example of that. Family court was kind of a break-off only about almost 9 years ago, and Johnson County, Kent's Judicial District, was the first county to start an exclusive family court, so that those judges would have both the expertise, they build up that expertise and have the training to deal with difficult people, good people in difficult situations, but that it would be a way for also one judge with one family. It wouldn't be a family coming in for a hearing here in September, and then they're going to come back, believe it or not, they do come back, in December, because they have some Christmas visitation issue, and the same judge would hear it, so they have a history with them. Before, they could be bouncing around all sorts of different judges. We also have 6 judges who hear criminal cases. That's what I'm one of the 6 judges hearing criminal cases in Johnson County. And that covers everything, literally, from disorderly conduct, fights, all the way up to capital murder, the whole gambit. There's also judges for juvenile court. There are 5 judges who hear civil cases. Civil cases are breach of contract, business breakups, medical malpractice, car wrecks, negligence cases, all of those things. So there are judges that hear each one of these components that you may come into court for. There's also, as part of the juvenile or probate, includes adoptions, child in need of care. If you've heard any of these or you hear about them on the news, those are most likely all in district courts. One of the questions that I wanted to at least lay the groundwork, and Karen and Dan will tell you their differences, but to talk about merit selection in Johnson County. 10th Judicial District in 1972, the Johnson County voted. It's all by election, or by a yes or no, how to select your judges. They were revamping the court system in Kansas. Johnson County had the vote, and it passed I wrote down these numbers. It is kind of interesting. A total of 55,000 people voted, approximately. 73.8% of the people said we should have merit selection. It came back up on the ballot again in 1984, and there was 104,000 votes for that election. 61, almost 62% said we should keep the system we have of merit selection. And many of you may remember, and I know that a lot of you were involved in 2008, most recent time that it was brought up on the ballot in Johnson County, 267,000 votes. And it passed with 59%, which is a remarkable, I thought, a remarkable victory, asserting that it is the right system for Johnson County. Now, all you have to do is look to Wyandotte County. They elect their judges. Sedgwick County elects their judges. So urban counties, suburban counties, it's whatever the people want to have to choose their judges. I happen to think that merit selection is better, but there are many things that are good about electing of judges. I will tell you, elections are partisan elections. You declare a party, and you're on the ballot. You have a primary. You may run against someone else in the primary, and then run against the other party or the other major party candidate in the general election. I want to, as Janice said, and Karen have both been on the Nominating Commission, which came into effect in 1972 or 73. They will vet every applicant who wants to apply to become a district court judge when there is an opening. I will tell you, we don't have all our slides here, so you have to write this down if you want to take a look. But to be a form of information for you is to look at the Judicial District Nominating Commission website, which is at www.joco, jnc.org. That gives the history, tells who's the members, has minutes from previous meetings. What occurs when a spot is open, and very timely that there is an open spot. Now, the names and applications were required to be turned in by Thursday at noon of this past week. There are 10 attorneys who have applied for an open spot that will be would otherwise be on the ballot for Division 4. Terry Elliott has been on the bench, I think, since 1991, and he is retiring. He is retiring because he has to retire by age. He is one of those, the laws changed several times, but you can be a judge, district court judge, until you're 75. Or on the ballot, as long as it's before age 75, and that was Terry. He's now, he doesn't mind, he knows everybody knows this. He's 78, almost 79. Still carrying a full caseload, doing a great job, but his spot would be up on the ballot. Now, because he's over 75, he can't be on the ballot. So of those 10 people who have submitted their applications, to say that some of you may work for the federal government, or you've applied for a job with the federal government. You know that 44-page application you have to go through? Very similar to becoming a district court judge. They want to know everything about you. They've actually culled it down, and I'm not just blowing smoke here, because Karen is here, and Karen was on the commission when I was chosen, but she streamlined a lot of this and made it a more meaningful. They'd always kind of tweak the forms and the questions and the process they go through, which I will tell you, and I'm going to give you the dates here, is an open meeting. Anybody can come to the Nominating Commission's session when they're interviewing these people. And I encourage you to do that. I'll go over, when I have a break, I go over and watch it. It's very interesting. Much more interesting seeing it from that side than it is being grilled, believe me. It's now, I believe it's a 15-page application, and with that, it covers everything from, first off, are you at least 30 years old and not 75 yet, because if you are, you can't be a judge. So it's anyone who's an attorney. I believe you have to practice at least 5 years, and at least age 30 up to 75. They will ask for all of your background information. They'll do a criminal history check on you. And believe it or not, attorneys do get in trouble sometimes. And some people have applied, even with a criminal history, and that eliminated them from the process once that was out there. They ask if you've had any ethical complaints or disciplinary complaints with the Attorney Disciplinary Committee for the state, which governs all attorneys in the state. They ask for, give us your 5 most significant legal cases you've been involved in, and tell us about it. What was unique about it? Why is it special to you? They also ask for, in references, everybody always gets reference letters, and people literally will send in notebooks of saying, look, I got 540 people who support me. They don't like that. But the interesting thing is they ask for, tell us who the attorneys were on the other side of the case. They contact the other attorneys and say, how was he to work with in this case? It's very revealing because attorneys don't usually hold back their opinions. They'll also get a financial history. They do credit checks on everyone. There's been people who've applied who've been through bankruptcy. And that doesn't really look real good. Sometimes voluntary, sometimes involuntary bankruptcy. So also ask whether or not you have ever sued any of your clients, or if any of your clients have sued you for malpractice. So your whole life is opened up, believe me. The Nominating Commission is made up of 14 people because we have 7 county commissioners in Johnson County. Each commissioner appoints a citizen, or a non-lawyer. I'd like to say a person. And then we have 7 lawyers. The lawyers are chosen by, there are a little over 3,500 registered attorneys that either live in or work in Johnson County. And we vote on that when there is an open spot, 2-year and 4-year terms. So those 7 attorneys, along with the 7 people, 7 citizens, make up the commission. And it's also headed by a Supreme Court justice. Justice Biles is not our departmental justice. Justice Lee Johnson is our departmental justice. He is the head of the commission, a non-voting member, but he is the one that organizes and runs the program. The short and long of this for merit selection is that of those 14 people, they'll team up now. And again, this is what Judge Arnold-Burger helped coordinate and how it's evolved, and I think is a phenomenal process to vet these 10 people that have just put in their names asking to be a district court judge. One lawyer pairs up with one person, one non-lawyer, and they're assigned to each one of these applicants. They meet with them ahead of time. They talk with them about what the process is. I think now it's evolved to, they'll even give them, let's work on a softball question to start off, to get the process started. Because believe me, this is like, I likened it to walking into what would be the 21st century Star Chamber. You walk in, and there's maybe like the UN table, this big U-shaped table, and you kind of step in, and everyone's staring at you. You sit down, and so you feel like, the first question you always think is, why do you want to be a district court judge? They come up with a question, and they prepare them, but also importantly, they contact the lawyers and citizen members of the commission, contact every person that an attorney will put down as a reference. Now, not all the letters that are sent in, but any reference. They're asking for a personal reference that knows you personally and a professional reference in your practice. And they'll contact them. And actually what they do, too, is when they're asking about those, when they contact, say that an applicant puts you down as a personal reference, they'll contact you. I've spent over an hour on the phone before, I won't say with whom, but members of the commission, when they're calling, they ask about that person who they put you down. But they'll say, do you know any of these other 9 people? And if you do, they want to know about that. They have reviewed all of the applicants' notebooks, which include, especially for the citizens, to read through some of these, because they want some of your legal writing. Give us a brief or a motion or a pleading that you filed that is associated with these significant cases, and they're reading through these. This is what we would call a hot court, where they've read everything, they know everything by the time you walk in for your interview. and you have a 10 or 15-minute interview with this whole group. Each one of them gets a chance to ask you questions, and you're on stage. That's a big part. And Karen can tell you about, some people look good on paper, and they come in, and if they're not convincing when they come in, they maybe try it next time. That commission, I will tell you, is set for September 23rd at 1 p.m. at the County Administration Building. The commission will gather, and they will review those 10 applications together as a group. They'll probably come up with they're pairing up their teams and how they're going to proceed, and how many of those 10 they think are worthy of interviews. Then on October 14th, beginning at 8 a.m. and going until whenever, they will interview the applicants, and that's the process where you can see that all in work. The only time that you wouldn't be able to see what's happening is when they go into executive session, which is to actually discuss the applicants and take their votes. But the votes are announced. They come out and say who are the top 3. Out of these 10, they'll pick 3. Now, they have to pick at least 2. They will pick 3, I'm sure, that all these people who have applied are experienced and qualified, and I think, as far as I know, would make good district court judges, but you have to pick those 3. The nominating commission votes until they come up with their top 3, and then the following day, on October 15th, or if that's a Friday, it'd be on the Monday, those 3 names and their applications are officially sent to the governor, and the clock starts ticking for the governor then to pick from those 3. That is the merit selection system that you have to pick judges here in Johnson County, as opposed to, you all would be very informed if it was an election, I think. But if you don't know about judges, nobody knows about judges unless they're involved with one in a case, and they say, that guy had no idea what was really going on. Or he knew everything because you won the case. You know, he's the greatest judge in the world. Another timely issue is, and I'm going to turn it over to Karen, because I've probably gone much longer than I should have here, but the process is similar, and there's differences that Karen and Justice Biles can talk about. There used to be, starting in 2006, a commission on judicial performance that would evaluate judges, take surveys from attorneys, non-attorneys, court staff, litigants, jury members, and they would evaluate judges. I came on in 2008, which was the first time that they did that statewide, but I think they only did half the judges that year. In 2010, my first time I was on the ballot for retention, I had that evaluation. After 2010, the funding for that evaluation was eliminated because it cost $700,000 to do that evaluation across the state for every district court judge, every magistrate judge, every appellate judge. Johnson County Bar Association here in Johnson County used to do a much less formal but a judicial evaluation. Well, we knew coming up 2 years ago, we tried to start that, and it wasn't statistically relevant the way that, because we got it out too late. We got it started early this year, and we had over 475 responses. Now that's out of 3,700 or 3,500 attorneys in Johnson County. It's just a survey among attorneys, but it's an even higher number because it's only attorneys. The only attorneys who are supposed to have turned in an evaluation are those who have appeared in front of the particular judge. They can comment on any judge they've appeared in front of in the past 2 years. So we figured there are a lot of attorneys that never go to court. It's usually about 2/3 of the attorneys that never appear in court. So if you took 1/3 of those attorneys, about 1,200 or 1,250, our response rate was close to 39% of the attorneys evaluated the judges. That will be coming out next week. You'll see it. It'll be on social media. It'll be in the press. It'll be on the Johnson County Courts website. It'll be on the Johnson County Bar Association website. And that is jocobar.org if you want to look at that. And the important thing, too, is it evaluates every judge. Even Judge Elliott, who's retiring. I said, you know, he wants to know because we get that feedback, too, and we'll get any personal comments. Those aren't made public, but if any personal comments when people are doing the surveys, we get those because we need the feedback on what we're doing right or wrong. Now, there are only, of those 23 judges, there's only 12 that are on the ballot for retention, and it's going to be down at the very bottom, so don't forget. And I'll throw in my one pitch, because I'm sure everybody's had this happen before. Had a friend whose mother, God love her, she's in her 80s, and my friend said, Mom wanted to make sure that you knew that she voted for you. I said, well, that's nice. I really appreciate that. I said, did you vote for everybody else? Oh, no, I don't know any of them. That's not the point. It's not, do you know this person? It's should they be retained in office? That's the question. So with that, I'm going to turn that over to you.
Okay, well, I'm on the Kansas Court of Appeals now, and so just a little bit about what I do, and I'll talk briefly about Selection 2, is anybody that appears before Judge Ryan and is dissatisfied with the decision he makes in the case has an absolute right to appeal his decision to the Kansas Court of Appeals, and we're required to take that case. So it's not discretionary. Any appeal from the district courts, they all come to the Kansas Court of Appeals. Now, the Kansas Court of Appeals is considered an intermediate appellate court. Some states don't have an intermediate appellate court. All they have is their Supreme Court, a few. But most states have adopted an intermediate appellate court system, and we did so in Kansas in 1977. What Judge Ryan didn't tell you is that the district courts in Kansas are set up under our Constitution. So they are what we call constitutional courts. The Kansas Constitution provides for district courts and has that provision in it that each judicial district can decide whether they want elected or merit-selected judges. Now I lost my complete train of thought. So they can appeal to us, and we must take their case. We set in, Constitutional Court, your Constitutional Court. We were set up by statute in 1977. So we're called a statutory court. So if there are ever any changes to be made to the district court, it requires a constitutional amendment. Likewise, Justice Biles is on the Kansas Supreme Court, and that is set up in the Kansas Constitution. So if there are any changes to be made to how Supreme Court justices are selected or anything to do with the Supreme Court, that requires a constitutional amendment. We, however, are a statutory court. So if there are any changes to be made to the Kansas Court of Appeals, they can be made simply by majority members of the Kansas legislature. So we were set up in 1977 to help alleviate some of the caseload from the Kansas Supreme Court. We sit in panels of 3. So we will set cases for oral argument or for decision in groups of 3. There are 14 of us total. When we started out in 1977, there were only 7. Now we've grown as the years go on. There are now 14 of us. 6 of us are on the ballot for retention this year. But those, we sit in groups of 3, and we sit all over the state of Kansas generally. So each month there are at least 4 panels, sometimes 5, that go out and hear cases in different parts of the state. So we'll usually have a panel in Kansas City, Kansas, usually a panel in Wichita. Next month I think we have a panel in Goodland. We've been to, I think in November I'm in Ottawa. So we just, and it's randomly assigned panels. But we try to go out to different parts of the state so that we can meet the people in those areas. It makes it much easier for the litigants if they have a case from the Goodland area to not make them drive all the way into Topeka. It cuts down the costs for the litigants. We also just started a program where we're allowing video appearance. So we actually, when we hear cases in Topeka, attorneys, if they want, can choose to appear and do their oral argument by video. And we actually have this big video monitor in front of us, and they can see us and we can see them, and they're in their office arguing their case. So it's kind of a neat technological advancement. So we hear all of the cases that come through. We generally hear anywhere from 20 to 30 cases a month per panel. So we have about 1,800 cases a year we hear in the Kansas Court of Appeals. If a person is dissatisfied with the decision that the Court of Appeals makes, then they can appeal to the Kansas Supreme Court, and Justice Biles can tell you about that. But we are considered a high-volume court, as most intermediate courts are. A little bit, I just want to give you a little bit of history of background. Judge Ryan has told you about the selection system in Johnson County, the merit selection. To back up just a little bit, way back in history, you know, when we were first founded, we had the federal system was set up where the president would nominate someone, the Senate would confirm, and that's how a person would be appointed to be a federal judge. That's still the case today, and they have a lifetime appointment. Those two things, Senate confirmation and lifetime appointment, were two means by which the Founding Fathers thought they could protect the judicial branch, a separate and equal branch of government, from political influence. If they were lifetime appointed, they couldn't be, they couldn't do what the king did when we were first colonies, which was remove somebody if they didn't decide a case the way the king wanted them to decide it. So they have lifetime appointment. They also decided on Senate confirmation because they felt that these senators represented people from all over the country, and it would prevent a president from putting in just a crony or a friend as a judge, somebody that wasn't qualified. The Senate would put the kibosh on that. And in fact, probably the most recent example of that we have was when George W. Bush, if you remember, tried to appoint Harriet Miers, his chief counsel, to the United States Supreme Court. And she had never had a case before the Supreme Court. She wasn't a constitutional lawyer. And the Senate kind of went up in arms and said, look, this person isn't qualified. You've only selected them because they're a friend and a colleague. So he eventually withdrew her name. So that's the point of the Senate confirmation part. That's the way it was in most of the states then in the Union, is they also had a similar kind of executive appointment, confirmation, lifetime appointment. During the period of Andrew Jackson, and I won't go into too much history here, but Andrew Jackson was the guy that coined the term, to the victor go the spoils. And he was a populist, and he felt that at that time only white male property owners could vote. He thought that was too restrictive. He thought all white males should be able to vote. Regardless of whether they owned property. That was his thing, was the property ownership. So, and there was this democratic zeal that kind of came across the country with this populist movement. And so it was through this Jacksonian democracy period that places started electing their judges. They thought, we elect our representatives, let's elect our judges too. Well, almost from the minute that started happening, and in 1861, when Kansas became a state, we adopted that system. So every judge in Kansas in 1861, when we became a state, was an elected judge. Supreme Court justices and district court judges. Remember, there was no Court of Appeals. So they're all elected. And almost from the time it started, there were calls from the Kansas Bar Association and others that this was not a good system. That people were, the railroads were purchasing votes. I don't know if you know, but at that time there were not secret ballots in this country. You got the ballot from the opposing, from the party. So the Republican Party would give you, if you were running, you would have your ballots in your hand, and you would hand the person who was going into the voting booth your ballot, and they would then put that in. And so that's how people bought votes. They'd say, here's $2 and a ballot. You know, go put this ballot in and you can keep the $2. So the railroads were purchasing votes left and right, and so you had to be a supporter of the railroads to become a judge. And many, many people were saying this is a bad system. And the American Bar Association was just being founded, and Roscoe Pound, who was the head of that organization, said, you know, this has got to stop. And about that time, we started into what was called the Progressive Era with Teddy Roosevelt. Teddy Roosevelt was merit, you know, civil service, merit, get rid of the corruption that had been built by the Jacksonian democracy into the victor go the spoils. Let's get rid of that and have civil service and merit selection. And so the ABA picked up on that and said, you know, even this federal model is not perfect. It requires some has some political undertones. Let's have a merit selection system for judges, with the template being you have a nonpartisan commission that interviews all applicants. They then recommend the cream of the crop to the appointing authority, who makes their appointment. And then I think the original plan is then those people would be placed in for life, so that you have a merit selection system. That was being pushed by many, many people, including some presidents as they stepped. Grover Cleveland went around the country speaking in favor of this. They never could get any traction for it until 1940 in Missouri, when the Pendergast era was at its height. And they decided that he was running everything, including the judicial branch. And so Missouri, for the first time, adopted a merit selection plan. And that is why you often hear it referred of as the Missouri plan, because they were the first one to adopt it. So then we get merit selection in this country. We still don't have anything in Kansas. The Kansas Bar Association is pushing every year for a merit selection system. And it isn't until 1957 with the triple play that you've all heard about, where the governor, a lame duck governor resigns, the Chief Justice of the Supreme Court resigns, the lieutenant governor in his sole act as governor appoints the outgoing governor as Chief Justice of the Kansas Supreme Court. So they call it the triple play. People were outraged, and that very next election we changed to merit selection in Kansas for the Supreme Court justices. We still had elected district court judges all over the state, and again at that point we didn't have the Court of Appeals. When the Court of Appeals came into being in 1977, they decided to do the same system for selecting by statute, the same system for selecting Court of Appeals judges as they did for Supreme Court justices. So we also went through the same merit selection system that the Supreme Court did. That was changed in 2013 because we're a statutory court. We can be changed by statute. That system was changed so that now on the Court of Appeals, the governor can select whomever he wants for a position, and the Senate is subject to Senate confirmation, and then that person becomes a judge. Now, in all of these merit selection systems across the country and in Kansas, there's no longer a lifetime appointment. It's a retention. It's merit selection with retention. So every 4 years for Judge Ryan and I, every 6 years for Justice Biles, they go on the ballot for the voters to decide yes or no. Should you be retained or not be retained? That's the only decision with merit selected judges. So then, so now we are selected under, we are all selected really under a little different process. Judge Ryan has the 10th Judicial Nominating Commission. Some district judges in Kansas are elected by partisan elections. We have a system where the governor selects and the Senate confirms, more of what we call a federal model light. We call it federal model light because it's not lifetime appointment. It's still subject to a retention election. And then Justice Biles is, of course, subject to the constitutional mandate of a merit-selected system. So that's just a little history lesson of how we got to be where we are today and why you see judges in different parts of the state are selected differently, why there was the controversy in 2013 as to whether and how to change the selection method of Court of Appeals judges, and why you have seen in the past and may see in the future controversies about constitutional amendments to change the way Supreme Court justices are selected. Thank you.
Well, let me, we want to have plenty of time for your questions, so let me just touch on a few quick things. First of all, if you want to see for yourself what the Supreme Court does, you can tune in on your computer over the internet. We live stream our oral arguments. We begin our term on Monday, next Monday, and so at 9 o'clock, and at 9 o'clock every morning next week, we will be hearing cases. And so you can get on there and watch us do what we do. Actually, we've got some interesting cases next week. The very first one that's being heard is a man who was convicted of being a sexually violent predator. The Attorney General wanted to have him committed involuntarily for care and treatment, which the law allows, but then he waited 4 years before after 4 years, he had not had a trial on the allegation. So the question is, was his right of due process violated? So we'll be arguing that. Later in that same day, we've got a rare disciplinary case involving a district court judge who's up in front of us for the second time. So those are interesting cases for the public. Those of you who are interested in school finance, this is the most I'm going to talk about any cases pending, or what I'm saying right now. But school finance will be heard on a special setting on September 21st at 9 a.m. Again, it'll be live streamed. You can tune in. That will probably, if I had to guess from other arguments, that's probably going to be a 2-hour. We have all morning set aside for it, but I think it's going to take all morning to get through it. Now, we have this rule about not being able to talk about pending cases, and so none of your questions can ask me about pending cases. We're so attuned to that Justice Stiegel, Caleb Stiegel and I were down in Arc City a month ago, and someone asked a school finance question. And it was his turn. He goes through this whole thing. We can't talk about it. We've got these ethical codes and all of that. And then we pass off the microphone, and the microphone comes to me, and I said, September 21st at 9 a.m. And he said, thank you, that's what I wanted to know. So we can go on automatic pilot. Real quickly, let me tell you about our court. We have 7 members, all selected through a nominating commission that's comprised of 5 lawyers and 4 gubernatorial appointees. That's a constitutional system. All 7 members of our court are native Kansans, very strong ties to the state. 5 of us are on the ballot for retention. That's only because of kind of the circumstances of how that particular position either was vacated at different times, and so it just happens to be a target-rich environment, if you will. So that's the court. Our jurisdiction comes from the Kansas Constitution. There are and statute. So there are some cases that can come to us directly as what's called an original action. They're just like a district court case, and come right to us. We have limitations on those kind of cases. That can't be facts in dispute and other details, but it can go directly to the Kansas Supreme Court in some instances. You can get to the Kansas Supreme Court from the district court if it's a criminal case involving a very serious sentence, a life sentence. So, a murder case would come directly to us and would skip the Court of Appeals. That became a problem right when I got on the court in 2009. There was a statutory scheme called Jessica's Law that the legislature enacted. It required, it was child sex cases, and it required, if you were convicted, a 25-year minimum sentence. Well, that was considered a life sentence, so all of those cases came into our court, and it was a mess for a long time. We had hundreds and hundreds of cases involved. It's actually opened my eyes to what a problem that is, but we just had tons of these cases coming on top of the other cases that we get. We can decide to take cases that come from the Court of Appeals. They're called petitions for review. Somebody doesn't like what happened at the Court of Appeals. They can ask us to take it, and we can decide whether we want to or not. We get about 1,000 of those a year. Depending on the year, we'll take from 15 or 20 to, there's been a couple years where we've taken 100 or so. We've learned that lesson. But it's a discretionary kind of thing. You look at the case, you look, what good is it going to do on a statewide basis, or do we think they really, really got it wrong? Or it's a question that where panels of the Court of Appeals conflict. So that's how we, so if these panels are not agreeing among themselves what the law is, then maybe we ought to decide. And on matters of Kansas law, we are the final decider of that. If we can also, all of our courts can decide federal issues. Judge Ryan would answer a search and seizure question, for example. That's a Fourth Amendment to the United States Constitution question. So how he looks at it, how the Court of Appeals looks at it, how we look at it, can still be looked at by the United States Supreme Court. So if it's a federal question, the United States Supreme Court is the final answer. And the case would go from our court directly to the United States Supreme Court. I don't really know good numbers. A lot of criminal cases, they seek review of ours. They seek review from the United States Supreme Court. It's fairly rare for that to be granted. So that's kind of the business of the court. The thing I wanted to take just a couple of minutes to give you is what I think ought to be the performance measures that you hold the courts to, regardless of which court it is. At the district court level, particularly, your county court, you get both administrative matters, I call them administrative, as well as court cases. So you want a marriage license, you go to the county court to get it. If you're a business and you want to check the records for land title, that kind of thing, you get that through the district court. So there are a variety of areas where it's not always lawsuits, on one side against another. So, and then of course we have litigation. I think there are 5 measures that you should hold the court system to. They are the same 5 measures that your Supreme Court uses when we try to figure out whether these guys are doing a good job. Because not only do we decide cases, we are the administrator for the entire judicial branch. So those are, number 1, is the court open and accessible? When you want a marriage license, you want to go to the courthouse and you want the door to be open. But you also want it to be accessible. What you need is the fee that's attached to doing something, manageable. I can't say reasonable because that's really in the eye of the beholder, but is it manageable? If you want to file a lawsuit, if you're a business owner and you've got a small debt, a bad check or something, how much do you have to pay to try to collect on that contract or that debt just to get into the door? And that's not hiring a lawyer. That's just, is this accessible? That one point has been challenging in the period of time that I've been on the Supreme Court. I sat on the Supreme Court the first time we ever had to shut down the entire Kansas judicial branch of government because we ran out of money. And that's because the first year that I was on it, sounds like I get the responsibility for this, but the first year I was on, in 2009, the legislature made a $15 million arithmetic mistake. This is before the days when they had fun wanting to cut us. It was just a mistake. But the appropriation bill was short. And everybody told us early on, we'll get it fixed. Next session, and that had traditionally been what had happened. But what happened in 2009? A recession hit. So by about August, we're hearing there's not going to be enough money to fill that in. And so we had to we thought we were going to be closed for more than 30 days. Now think about closing down your court system for 30 days. And that's what we had to plan for. By the time we were done, not filling vacancies and saving money, and then with what the legislature gave us, we ended up being about $5 million short, and then it got down a little lower, and we closed for 4 days. And we had to stagger it so that it wouldn't affect our employees any more than it was going to. We actually have employees, several hundred employees in the judicial branch that make below the federal poverty line. And so when you're trying to manage how you do that, and there are ways you can get unemployment compensation, that kind of thing, we had to do that. Now, while we're figuring that problem out, we are not writing opinions. And one of the justices estimated that we lost about 30 writing days during that period of time. And then we had to close the court one other time in order to make sure we had enough money to make it to the end of the fiscal year. So open and accessible is not as simple as it sounds. The second measure is this is service courteous. When you get there, are people nice to you? Or are they mean to you? Are the judges mean to you? I think that's reasonable to expect. The third thing, is it efficient? You know, if you want your marriage license, can you show up? Can you actually get it without standing in line for it? The fourth thing, is it competent? I mean, just are they doing what they're supposed to do? Does it say what it needs to say when they hand you your marriage license? The fifth one only comes in when a decision needs to be made, and usually that's when we're talking about court cases. And that is the decision-making fair and impartial? And, you know, there are subparts under those 5 categories, but I would suggest to you that when you're looking at what you're getting from your district court or the Court of Appeals, or certainly from the judicial branch in general, and that falls on the Supreme Court, are you getting those 5 things? And so now let's get to the question.